the Honorable E. Gary Early is a perjurer with malice and wanton disregard for people's rights. The worst part about it is that Mr. Early is a judge who lies about things he has no power to lie about. Now, I'm using the term perjury in its legal sense. In Florida law, it means telling the government a known false statement of material fact. Judge Early did that on April 18th, 2019. He told the Florida Commission on Human Relations that my employment discrimination case was not based on sex discrimination. It was. He knew it was. He lied to the government. He did so to establish the basis for his false narrative to violate my constitutional rights. Due process, equal protection. Here's how it happened. On June 30th, 2017, I filed an employment discrimination complaint with the FCHR. I charged Allstate Insurance Company with race discrimination and sex discrimination. The first page of that complaint says race discrimination and it says sex discrimination. The first page. On September 8th, 2017, Allstate filed its response. The first page of its official position statement acknowledged that my complaint was, quote, based on race discrimination and sex discrimination, end quote. Allstate also stated that it fired me solely because I failed an actuarial exam. You'll see why that's pivotal in a moment. On December 15th, 2017, the FCHR concluded its investigation into my charges against Allstate, notably affirming that my employment discrimination complaint was based on race and sex discrimination. The next month, I requested a hearing. The FCHR transmitted my complaint to DOA. DOA, of course, has administrative law judges who hold hearings. E. Gary Early is one of those judges. It's important to note that my hearing request, what they call a, quote, petition for relief, listed only race and sex discrimination as the protected characteristics in my complaint. In November 2018, we went to trial. By this time, Judge Early had already taken over the case. He did so after a series of irregularities, deposition sit-ins, recusals, personal attacks against me. At trial, however, the facts continue to fall in my favor. You can watch this video to get a deeper look into Allstate's discrimination against me. One crucial fact was that Allstate made me pay $1,025 for an actuarial exam fee, but never made any of its other employees make that payment. None of its other employees, of course, were in my demographic. A second material fact was that Allstate never fired any of its other employees for failing exams, and there were many. These facts made my case against Allstate a textbook case of employment discrimination. Unfortunately, though, these facts also ran counter to widespread propaganda. Propaganda spread by the Ku Klux Klan itself. So, Judge Early went on the attack. One of the first things Judge Early tried to do was conceal the fact about the $1,000 payment disparity. At trial, as it was being revealed, Judge Early ordered me to cease questioning. After trial, I asked him for a redress of the cessation order. In January 2019, the court reporter sent DOA the trial transcripts. Mr. Early intercepted it and scanned it in, a job that's mainly done by non-judges. The 1,200-page transcript was missing one page and one page only. The only missing page was the one pinpointing the $1,000 payment disparity and the cessation order. Based on facts and circumstances, Judge Early willfully and knowingly hid evidence, and I must repeat, scanning and docketing transcripts was not his job. The second crucial attack was his perjury. On April 18, 2019, Judge E. Gary Early committed perjury. He did so in his self-authored recommended order. The first page of that document had a section titled Statement of the Issues. In it, he excluded my sex discrimination charge. The second page of that document had a section titled Preliminary Statement. That's where he made the fateful declaration that I never complained about sex discrimination. He wrote, quote, "The petitioner also, for the first identifiable time, alleged that Allstate, and in particular, engaged in sexually provocative and inappropriate behaviors, which petitioner alleged to be sexual harassment and discrimination," end quote. He repeated that line, quote, "for the first identifiable time," several more times throughout his written piece. That statement, of course, is false. Please see parts 1 through 3 of this video. Crucially, those two statements form the basis of his recommendation, a recommendation based on perjury, a recommendation that devolved into a fictional, stereotyped slander, a recommendation that violated my constitutional rights, due process, and equal protection. Of course, it's also important to note that Judge Early knew he was lying. Prior to authoring his recommendation, Judge Early deliberately acknowledged that the sex discrimination charge was in my original complaint. On February 6, 2019, Allstate moved Judge Early to take official recognition of the FCHR's determination. That determination letter read as follows, quote, "Complainant worked for respondent as an actuary. Complainant alleged that respondent discriminated against him based on his race and sex," end quote. On February 18, 2019, Judge Early granted that motion, thereby cementing unequivocally that he knew that I charged Allstate with sex discrimination. On that day, he wrote, "This document, quote, provided the point of entry to petitioner for this proceeding," end quote. Thus, Judge Early's repeated statements to the contrary were a known lie, a massive lie. So that's how Judge E. Gary Early perjured himself. He could not handle the facts of my case, so he took the law into his own hands, following the propaganda of the Ku Klux Klan. He hid evidence, and he committed perjury. As a legal note, Mr. Early's first statement in which he excluded my sex discrimination complaint was what is called a condition precedent. It required no judgment, no discretion, and no fact-finding. It was just a non-judicial act that anyone could have completed. In fact, he did not even have the power to change the condition precedent. The FCHR has repeatedly said that only the FCHR has substantive jurisdiction over what's been charged. DOA has acknowledged this too. Florida's appellate courts have as well, and so have federal courts. Yet Judge Early, in his personal quest to infringe my constitutional rights to due process, decided he'd take the law into his own hands. Judge Edward Gary Early of Tallahassee, Florida, perjured himself in 2019.